last lecture we have started in last lecture we all have started with pleading, right? So we all have seen what are the ancient traces of pleading, what was their olden pure view of it, right? Then we have seen what does pleading mean according to the civil procedure code, and later we have seen certain fundamental rules of pleading, right? So I hope you all are remember what are those four rules. And today, without wasting time, I am going ahead with your drafting structure of a plea. Okay, it's not a specimen form, but there I have mentioned certain things which will be understood by you. What are the things needed to be filled when we are going to start writing or start drafting a plea. Okay, and after completion of Plaint, again with collaborating with Plaint, we all are going to see what is affidavit. Okay, if time permits. Okay, so I request everyone to mute your mics. Okay. I hope my screen is visible, everyone.
Yes, ma'am.
Okay.
Yes, ma'am.
See, those who know what is Plaint or they all are practicing in a court, they know that this is just a general or simpler form of a plain structure. Okay? But as we are having a mixed audience over here, I have represented a very basic idea about how a plain structure should be and what needed to be mentioned whenever we are going to approach it. Okay? So basically, when we all are dealing with Plaint, it is contained or it is there are certain provisions which are provided under Order 7, Rule 1 of Civil Procedure. Okay, so according to those rule, there are total, I can say that more than 8 to 7 pointers, which are mandatory pointers regarding to what needed to be mentioned when you are dealing or when you are going to make a plain structure. Okay, these are very general terms which can be discussed also. Okay, so first point is there regarding to the name and the court in which the suit is going to be brought. Okay, second is the name and description of a place of residence of the plaintiff. Second, thirdly, the name, description, and place of the resident of the defendant. Okay, as if they wanted to be an asserted. Okay, next is where the plaintiff or the defendant is minor or is a person of unsound mind. Okay, a statement to that effect we need to make. A statement means a affirmation or a statement where we can say that from this we are starting with our main body of it. Okay, next is the facts consulting the cause of action and when it is arose. Okay, next is the relief which the plaintiff claims. And next is where the plaintiff has allowed a set of or relinquish a portion of his claim, the amount allowed or the relinquished matter which has been said of. Okay. And as last, there is a statement of the value of subject matter of a suit for purpose of jurisdiction and court fee so as far the case admits. This is what Order 7 Rule 1 talks about. Now, leave this apart because this is so technical language. According to this, we need to follow the structure. It's so easy. Let's not go to the technical terminology. Okay. Now, when I am talking according to Order 7, Rule 1, Clause A of our plain structure or civil procedure code, okay, it's talk about the heading and title. As you all can see, I have written over here in the Court of Civil Judge Senior Division, or we write in the Judicature of High Court of Bombay, of Punjab, original jurisdiction we need to write. filed will be indicated, and it is always indicated at the top of your first page. Next is we write about heading of the plaint, means the court in which the suit is to be instituted. Okay, and this has been guided by the Order 7, Rule 1, Clause A of our Civil Procedure Code. Okay, as you all can see how I have mentioned. Okay, then we start with the main lining. Now after writing it here, you need to write suit number, whatever it is, let's say that 2346 of 2024. Okay, like this we write the suit number. So we say that before the heading of a plaint, proper space should be left for affixing code fee stamp just below the name of the code, and space should be left for the number of the suit. It is as such suit number, as I have talked of, the current year at what time you guys are approaching. Okay. Thereafter, we write about the name of the parties to the suit with all necessary particulars which are given. Okay. So, for example, I have written over here, let's say that AB, son of CD, we need to write the Mumbai, we need to write a whole address. Okay. And then we write he is a plaintiff. Versus TQ, son of RS, age, let's say that 42 years, resident of again Mumbai, and again we write a whole address and then we write different. Okay, now even I have mentioned about if there are more plenty for defendant, then the names of the plaintiff and the defendant should be given in plaint as plaint number one, defendant number one. Let's say that if I'm writing this is a plaint number, this is a plaint number one. Okay, so if there is another 2 to 4 parties, plaint number one, then we start with plaint number 1, 2, 3, 4, however parties are. Okay, if there are more defendants, we need to write all the defendants name over there. Okay, then after the name of the party, we need to give the title. Okay, title to the suit. Which suit actually this is? Okay, so as I have given the example, like, is this a suit for specific performance and damages? Do this is a suit for recovery of money? Or do this is a suit for damage for malicious prosecution? Or do this is a petition for judicial separation under Section 9 of Hindu Marriage Act of 1955? Like this, you all need to mention regarding to the title of your suit. Okay, if we are talking about ADR, so there should be the alternative dispute resolution according to section 11, where the award has been given to the parties. Like this, we are giving the title. Okay, now let's say that if the plaintiff or defendant is minor or unsound mind at that time. So at the time, what we need to do, you need there the fact should be mentioned in the cause title, and at the same time, what can be done? The name and the description of the person through whom such person sues or being sued should be given at the cause of your title. Okay, so the forms I have given over here. Okay, let's say that if plaintiff or defendant will be needed a special assistant in framing the cause title in particular cases, so how it needed to be right. So if it is there for an individual person, like how we have written over here. Okay, I'll mark, right, like this is for individual persons, how we write the names. Okay, but what happens? Am I audible, everyone?
Yes,
Yes,
ma'am.
ma'am.
Yes.
Okay, so sorry, I just bumped out from the meeting. I don't know how. Okay, again, I'll share my screen and I'll share those things with you. I hope you are getting it easy, right? The way I have created. Okay, I hope now this is easy to. Yeah, okay. So, as I was talking about, when we are talking about an individual person, okay, so we just write the name of that individual. That the individual name. Let's say that it's my name. That is Pranjali Bhavne, daughter of my father's name Prashant Bhavne, age 25 years, residence of Pune. Like this, we are going to write the individual person's details. Okay, now let's say that it is there regarding to the proprietary concerns. Okay, this is there regarding to any business, any partnership firm. Then how you write here also we're writing about an individual person, where proprietor of whom, okay, of Mrs. XYZ carrying on business at, like this we need to write the name over here. Okay, next is there regarding, oh yeah, I have mentioned about partnership firm. Okay, let's say that Mr. Mrs. XYZ, a partnership firm registered under Indian Partnership Act of 1932 with its principal place of business at, we need to write the whole address of where they are having their office of business. Okay, if it is a company, same, we need to follow. This is a private limited company incorporated under Companies Act of 2013 or 16, having their registered office at, let's say that Mumbai or Pune, like this we write. Next is there regarding to the company in liquidation, we follow the same, we write about the name of the party, then we write about the liquidator, which is appointed by NCLT, National Company Law Tribunal, okay, or DRT. By this people, this liquidator has been appointed to you. That person's name, who's where his office has been situated, that we need to write over here. Okay, next is there regarding to the statutory corporation, how you are going to write, like the Life Insurance Corporation of India, established and constituted under the Life Insurance Act, having its register office at where they are having their center or where the location is located. Okay, if it is there for any municipality, you need to write Municipal Corporation of Delhi through its chairman, Town Hall Delhi, or Municipal Corporation of Delhi, on whom you're going to file that case, or the person who is whole self is the plaintiff, then he need to write his designation through its chairman, or I am being a first class officer, I am being a secretary, whatever position you have, you need to write over there. And same again, where your office or address and all, everything you need to write. Okay, if it is a minor, okay, so name of a minor, he's a son or daughter of, age of that minor, of course it will be below the 14 years of age, a minor through his father or natural guardian's name, we need to write father, mother, or any natural guardian. Hmm? Again, they need to write the son of, age, and residence of, whole address of that person. Okay, this is there regarding to your introductory part of your Plaint structure. Okay, now coming to the second part, interesting part. Okay, here we talks about a body of a Plaint. Okay, so when we all are dealing with a body of a plaint or body of the suit or a plaint, here the plaintiff is, or here the plaintiff acquaints the court and defendant with the case. How? Because here the statement of facts are divided into paragraphs. Okay, and we are numbering them accordingly. And as far as convenient, a paragraph should only contain one allegation. Don't put two to three allegations when you are writing about one paragraph. Okay. Next thing is there regarding to the date, time, numbers, expressing certain type of figure, as well as the words which you guys are going to use. And even whenever we are going to write about the plaint, it's always begins with the above named plaintiff state as follows. I hope you all can see. Okay, and as I told you, I follow the principles of Mogha whenever I have learned my drafting or pleading skills. Okay, I always follows his definition or uh, the representation of the structure of draft. So accordingly, today also I am discussing same with you. Okay, Mogha explained very well regarding to the two portions of your plain structure. Okay, as I have mentioned over here, one is substantive portion and second is formal portion. And even Moga is saying the law of pleading in India has divided into body of a plaint into two parts. So it is substantive and it is a formal part. Okay. Now, whenever I'm talking about this, the substantive portion of body of a plaint, okay, I have written over here also. Please pay attention. First part is statement of all facts constituting the cause of action over here. Okay. And secondly, what we mentioned, the facts showing the defendant's interest and their liability. But as already noted, often it is desirable to start the plaint with certain introductory statement called the matter of inducements. Okay, so these are nothing but your introductory structure or introductory statement means the affirmation you are giving. Okay, and coming to the second part that talks about the formal portion of your plaint. Okay, now formal, now see, substantive mean in depth of what you are going to mention inside of it. But if we compare it with the formal portion means you are stating the essential particulars which are needed when you are going to draft this plain structure. Okay, so how we follow, like this, how I have made the pointers. Okay, whenever we are going to make a formal portion regarding to what happened actually. So first we write about date when the cause of action arose. Okay, that my client whose name is Pranjali, she is the resident of Pune, the address of mine. Okay, where she was crossing the road, or let's say that when she have parked her bike near the Pune railway station, but when she came after 30 minutes the bike was not presented at that time. So at that time the time was 8:30 p.m. Okay, nearby there were many people, so it was really impossible for her to find it out. Normal thing I have mentioned over here. Okay, we don't make certain big things when we write about date and when the cause of action is. Okay, next is the statement of fact pertaining to the jurisdiction. Now, where she have parked the bike at the Pune railway station, where at the parking of Pune's railway station. So Pune's railway station become my jurisdiction area, where everything have happened. Okay. Third thing, we talk about the statement as to valuation of a suit for a purpose of jurisdiction, court fees, and it should be stated that the necessary court mean has been affected. Of course, if it is state of Maharashtra, how much suit valuation is there? Accordingly, we need to find under Stamp Act how much you need to pay when you are dealing with it. Okay, next is there regarding to any, as we have talked right now, it is there from a minority point or insanity of a party. If he is representing some other type of body or statement as a plaintiff is representative character over here. Let's say that I have a kid, so he is somewhere insane or he is unsound mind, so I will be a legal guardian of it. So through this minor or through this minor, he or she is a legal guardian of this. So whatever statement has been made, she will be responsible for it. I will be responsible. Okay. Next is when a suit is filed after the expiry, the period of limitation, and statement showing the ground or grounds on which he has claimed the exemption from limitation law. Let's say that there is an exemption of 60 days. Let's say that there is an exemption of 90 days. If I talk about the liquidation, okay, we guide it from for what purpose there is a liquidation. Do it corporated with companies law or insolvency or bankruptcy. Is there is a liquidation of company, so total 380 days has been given. Extended period will be one more 180 days over there. So according to the limitation law, we need to compare which law is going to govern. Okay, that we need to mention. Next is there regarding to every relief sought by plaintiff should be accurately worded. बराबर है. Our words are going to speak more louder when we are going to mention everything inside of our draft, right? So here we are discussing about rule 7 of our civil procedure. Okay, I have mentioned whole over here. Says that every plaintiff shall state specifically the relief which the plaintiff claims, either simply or in a alternative, and it shall not be necessary to ask for general or other relief which may always be given as the court may think, just to the same extent as if it had been asked for. And the same rule shall apply to any relief claimed by the defendant in his written state. मतलब आप जब ये फॉर्मल पोर्शन बनाने वाले हो, इसमें आपको एक रिलीफ पूछना है, आप एक रिलीफ मांग रहे हो, ठीक है, इसमें आप क्लेम्स लगाओगे, इसमें आप क्लेम्स लिखोगे. That's why we are writing this plea. If it is from a defendant's side, whatever allegation has been made by the plaintiff, we are going to answer all those. Okay, so plaintiff can claim more than one relief inside of this. He can seek relief alternatively also. And a plaintiff is entitled to claim more than one relief in respect of the same cause of action, and should sue for all of them because he is debarred from bringing a fresh suit in respect to the omitted reliefs, except when the omission in the first suit was with the permission of the court. This is order 2, rule 2 clause 3 of civil procedure code. Okay, this is understandable by reading also. Okay, if you wanted to ask a relief and the cause of action is same, so you can ask it is in your one plaint only. There is no need that you need to file a fresh suit for it. If the cause of action you feel it is an another one, the case is taking into an another way. First it was very general, but later it has been turned into an heinous one or turned into a very different mode. Yes, at that time we can think about it. Okay, next is there regarding to the signature and verification part. Okay, this is so necessary when we are talking about a plaint. As I have written, according to the civil procedure code, the plaintiff must be signed by the plaint must be signed by the plaintiff through the advocate. But if the plaintiff is by reason of absence or for good cause unable to sign the plaint, it must be signed by the person duly authorized by him to sign the same, and the verification is done by the plaintiff himself, either through the concerned authority. Okay, duly concerned authority, like to whom you are going to give importance as the first instance. Let's say that I wanted to file a plaint and I wanted to do a verification part. But if what if I am injured and I am admitted into a hospital, so my father will be the authority, my mother will be the authority, where I will be writing that I am giving this person authority of it. Okay, and as we are saying, the verification is done by the plaintiff himself. How? Because see how what we write in our verification part. I, we start with I. We are not writing about the advocate over here. We write about ourselves because you are filing through the advocate. Okay, so I, let's say that my name will be there. I, Pranjali Bhavani, son or daughter of Shri Prashant Bhavani, the aforesaid plaintiff, defendant, whatever. If you are plaintiff, you need to write plaintiff. If you are defendant, you need to write a defendant. Do hereby verify that the contents of paragraph 1 to 7 of the above plaint are true and correct within my personal knowledge, and that the content of para 1 to 7, okay, I believe to be true on information received. ओके मतलब ये जो आप नंबर डाले हैं आपने यहाँ पे फॉर्मल पोर्शन में 1 to 7, राइट, समझ लीजिए दिस आर माय explanatory or these are my main formal portion of it. What I wanted to say, this para's number will be given over here, and you are saying the information which you have wrote over here, that is true from my sense, and I am seen and I am knowledgeable what I have written inside of it. ठीक है, next is signed and verified at the court place will be there, मतलब wherever it is situated. Let's say that it's a court of Shivaji Nagar, that will be there on this day, on, let's say that today is 29th day of April 2024. It is signed by the plaintiff or the defendant. Then there are certain documents which you need to uh, attach with this. So as I have written over here, the affidavit we need to make according to order 6 rule 15 plus 4 of civil procedure code. There are list of documents which are given according to rule order 7 rule 14 plus 1 of civil procedure code. Accordingly, we need to attach all those documents over here. First, about your identity. If it is about authority, application of authority, then the identity of the authorities. Okay, all these things needed to be mentioned when we are dealing with this plaint structure. Okay, so understood everyone? Very in a general sense, I have mentioned all these things over here. Understood? Any doubt, any question?
Yes.
Ma'am, in some planes, I have read like the portion in which it contains the substantive informations about the facts and circumstances. In
Hmm.
that case, it's written like the plaintiff from the plaintiff side that all those informations are true and true to the best of my knowledge. And for the last
Yes.
portions, ma'am, like where the court fee and other legal related
Hmm.
things are mentioned, over there they write like that these things are true on the basis of the legal advice I have taken from my advocate.
Oh,
So
yeah, this is a modern
they,
form of drafting, Vipul. Many of you, many drafts you have seen like this, but we never write. Okay, if we wanted to make it professionally, we never write in this form. Ki this and this paragraphs are correct from my sense, but another are advised by my client. See, does it make a sense for you? Why we are having a lawyer? He's a representative of us, and he's going to state what I wanted to. And why we are saying ki whenever we are making a draft, with your client. Okay, what your client going to say, that only we are going to put over there. So of course it will be true of the knowledge of your client. This and these things have happened. That's why from 1 to 7 or para 1 to 8, however, how much they are there, that will be mentioned at that time. Don't write ऐसे कभी भी. Got my point, Vipul?
yes, ma'am.
ठीक है. Okay, आगे बढ़े फिर अभी. Let's talk about affidavits. See, affidavits are so easy. They are not rocket science at all. Okay. Um, Affidavit is something which you all know. Okay. So, can anyone give me idea regarding to what is affidavit actually? Yes.
Statement of facts
Yes, correct, Jenny ma'am. What else?
by taking the oath.
By taking
Any
oath, correct.
statement which is made under oath.
Okay, any statement which is made under oath. Okay. जनरल सेंस में बताओ, अगर मैं आपकी क्लाइंट हूं तो आप मुझे कैसे बताओगे कि ये क्या है?
Ma'am, it is a sort of a written statement which you can confirm that it is true statement.
What it is?
It is a true statement. Whatever mentioned is actually true.
Correct. So how you will counsel your client? Yes. Bolo.
Ma'am, self-declaration.
Yes, correct. Very good. बेसिकली हम कहेंगे कि आप सेल्फ डिक्लेरेशन कर रहे हो, आप जो कुछ कह रहे हो वो मेरे सेंस में है और मैं समझता हूँ या समझती हूँ कि मैं जो कुछ भी इसमें लिखने वाली हूँ वो करेक्ट ही है. इसलिए हम कहते हैं कि आई स्वेयर और आई एम टेकिंग अ ओथ. That's why the first point. I hope the screen is visible, everyone. No blackout, right? You can see, right?
Yes, ma'am. Yes, ma'am.
ठीक है, ठीक है. So basically, an affidavit is nothing but it is a sworn statement, as according to Jenny ma'am said, this is a oath. Okay, so it is a, we can say that it is a sworn statement in writing made specifically or specially under oath before an authorized officer. ठीक है. Therefore we need a great care when we are drafting our affidavit. Okay, so at a time to time a court may sufficiently reason regarding to order that any particular fact or any fact may be proved by the affidavit, or the affidavit of any particular witness may be read at hearing, proving that the court may order the deponent to appear in person in court, or they, if they wanted to do a cross examination of it, at that time we needed certain types of affidavit. There is a single form of affidavit, but whenever we want it for certain purpose, we are saying that we needed a affidavit of this person. Okay, and affidavits are being regularized, or it's been followed according to our order 19 rule 2 clause 1 of civil procedure code. Okay, so as I have talked, we are having a regulatory body of it. So in verification, it must be specified, okay, as to which portions are being sworn on the basis of the personal knowledge, and which on the person information received and believed to be true. And in the later cases, the sources from information, it must be disclosed or it must be stated. Okay, even there is also one more order, that is order 19 rule 3. Now we are talking about rule 2. Let's jump to rule 3. It is providing that affidavit should be confined to the facts where the deponent is having a knowledge to prove, expect and accept what he has been written. Okay, so what does it actually means? It means the statement which he is making, he is having a belief and he is admitting and he is providing the grounds of such belief which needed to be stated in front of a court. Okay, and depending upon that, we are having certain rules over there as how I have written over here. Okay, as I have written, not a single allegation more than is absolutely necessary should be insulted. Okay, एक allegation एक ही पैरा मिलेगा, या it will be stated in only one statement. Next statement, the second allegation. Okay, the person who is making the affidavit should be fully described inside of your affidavit which you are going to make. And whenever you are going to make this affidavit, it should be drawn up in the first person. मतलब I होगा वहां पे. I am making a oath, I affirm. Okay, through my client ऐसे नहीं लिखोगे आप यहाँ पे. As we are saying, this is a oath, this is a sworn statement, right? That's why. Next thing, and our affidavit again, it should be divided into paragraphs. It should be numbered. Okay, as far as possible for you, your each paragraph should be confined to the distinct portion of the subject. Subject means what you are going to state inside of it. Okay, next point is there ki every person or place which you are going to refer, okay, your affidavit should be correctly and fully described regarding it, so that person will be easily identified. Let's say that what identity proof you are going to give with your affidavit. Okay, let's say that if you are representing an Aadhaar card, so of course on Aadhaar card there is a detailed information of that person regarding with his permanent address. Okay, so same address which is there on his identity card, that you need to write or that you need to mention inside of that affidavit. Okay, now next point is there regarding to when your declarant speaks of any fact within his knowledge, he or she needed to do it directly and even positively, using the words like I affirm or I make an oath and say this and this. ठीक है? Now, next thing is there, 7th point. I'm on 7th point. Okay, it is there according to Order 19, Rule 8. Whenever we are talking about an affidavit, it should be confined of the matters which have happened, where the person is having the knowledge, and who is a declarant means he himself is a declarant. He should have a knowledge about it, and if any fact is within his personal knowledge and any person or a petition can secure his affidavit about it, then he should have to filled everything by himself, not through his lawyer or advocate. Okay, but there are certain types of interlocutory proceedings. Okay, sometimes when you are dealing with certain types of proceedings, here they are permitted to verify facts on the information received by them. Okay, so what type of statement you use when you're dealing with this? I am informed by so and so, before any allegation which has to be verified, and if the declarant believes the information is to be true, then he must add, I believe it to be true, or I make a oath and say this and this. Like this we are making the affirmation, or like this we are making the statement. Okay, if I am saying I am informed by so and so, इसका मतलब है वो इंसान वहां पे एक विटनेस है, ठीक है, या अगर वो प्लेंटिफ है तो इट हैज बीन इन्फॉर्म बाय वन ऑफ द विटनेसेस। ओके, जिसने बताया उसका रहना तो जरूरी है ना कोर्ट में, तो स्मार्ट वर्क यूज करना इस टाइम पे। ओके, नाउ नेक्स्ट पार्ट इज देयर रिगार्डिंग टू when the application or when the opposition on, or where the rest of the facts are disclosed in the documents or in the copies, here declarant needed to state that from where they have collected this data. It means the source from which they have produced certain types of information. Okay, now here again the statement comes. The sources from which they have produced certain types of information, they believe have, or they have a belief as to be truth, and facts disclosed in it or disclosed in certain types of documents are to be true of their sources. Okay? It's not like you are just talking about a mere rumors which have been spreaded over the people. No, you need to see by your eyes, and then you need to say, these are the sources, these are the evidence which I have with me. Okay, which I feel should be represented in my next hearing, or which should be represented if court asks. Okay, and next thing is the affirmation which needed to be right at the end. Okay, first affirmation which you all can use, that is, I swear that this my declaration is true, that it conceals nothing, and that no part of it is false. So this is a general affirmation which is used by everyone nowadays. Okay, and second information which you all can use, that is, I solemnly affirm that this my declaration is true, that it is conceals nothing and no part of it is false. Okay, if there are any alteration regarding to the statement you are making, or there are any alteration regarding to any part of your affidavit, okay, it should be authenticated by the officers of in charge over there, okay, before whom the person have been sworn. Okay, next is there regarding to the charges which needed to be paid. It is there, Article 4, Schedule 1 of Stamp Act 1899. Okay, so here we talk about the duty which is charged on the affidavits which are filed or which are used inside of a court, and same affidavits are liable for the payment of court fee prescribed from various courts. For, let's say that if it is a district court, the court fee may be different. If it is Maharashtra, it may be different. If it's Delhi, it is different. Okay, it depends upon where you have filed it. Okay, and depending upon the same, now we are going to see the specimen form of the affidavit. Okay, so basically this is a structure of an affidavit, very general structure of affidavit I have. Okay, so this is a specimen form of affidavit of a creditor in proof of his debt in proceeding for liquidation of a company. Okay, so in the High Court of Bombay Judicature in the matter of Companies Act of 1956 and the matter of liquidation of, let's say that, Coca-Cola Company Limited, Private Limited. I, AB, age 60 years, son of Shri, resident of Bombay, do hereby on oath or on solemn affirmation state as follows. First pointer, that the above named company was on whatever day of 2013, the date of order from winding up of the same, and still is justly and truly indebted to me sum of rupees, let's say that 50 lakh 1 crore, only an account, describe briefly the nature of a debt. How much debt that company is having, that's why it is going through a liquidation process. So it will be always more than 10 lakh rupees. Okay? Or most of time, if we talk from a today's scenario point, it will be more than 100 crores or sometimes more than 50 crores. Okay? Next is that in a proof of a aforesaid debt, I attach thereto documents marked A, B and C. यहाँ पे आप नहीं लिखोगे index or annexure or schedule. You will write your marking documents. Okay, document A, document B, document C. Whatever receipt, whatever bank transaction, whatever things you have, that you need to write over there. Okay, third thing, that I have not nor have any person or persons by my order or to my knowledge or belief for my use received the aforesaid sum of rupees 50 crores or any part thereof or any security or satisfaction for the same or any part thereof expect the sum or security. Okay, state the exact amount of security, how much assets, the worth of that security, or whatever security can be anything over here that you need to mention very specifically. And fourth, this is my affidavit is true, that it conceals nothing and no part of it is false. And at the right side of the right corner, we write signed by AB, name, signature. Okay, and then we write about the verification part of it. I, the above named deponent, verify that the contents of paragraph 1 to 4 of this affidavit are true of my personal knowledge and again signed by AB. Okay, date we need to write. I dash son or resident declare for my pursuit of the paper proceed by the deponent before me and I am satisfied that he is Shri AB. Okay, signed solemnly affirmed before me on this dash dash day of 2013 of time by the deponent, signed oath commissioner. Means the here I ये जो papers वाला part we are writing here, the name of that commissioner or law officer's name will be there in front of whom this oath has been taken. Okay, ऐसे बनता है आपका affidavit and this is one of the easiest part of making an affidavit. Okay, here I have taken the toughest part of affidavit, that is creditor in proof of his debt in proceeding for a liquidation of company. The affidavit can be for anything, recovery of money, suit of money, it may be of motor vehicle act, anything will be there, easiest part. Okay, so this is how it works when we are talking about affidavits. So understood the plain structure and affidavit part, everyone? Yes?
Yes, ma'am.
Great. Any doubt, any questions regarding to this? Now, as we are having many of the working advocates over here. Yes? Okay. Understood, everyone? At least say yes or no.
Yeah, broad structure understood, ma'am, but it will take a time for us to register. For serving advocates, it is a cakewalk. For others, it will take a bit of time.
Yes. What I am going to do on within next 2 to 3 days, once I complete your whole sessions, okay, I'll share some type of plain structure with you. It will be shared by Akshay with on your group. Okay. So it will be fine if you read those basic structure, and then if you wanted to practice, you can make those. So that will be easy for you. Okay, I'll share more 3 to 4, so it will be easy for you, and they are made by very good draftsmen. Okay. The things which I have shared with you, they are very at very general level, that very at first instance, because we are having all practicing advocates, we are having students of law also. So I needed to be very focused on the general part of it. Okay. So I'll share all those with you. You guys read about it and then follow, and then you can ask me the questions regarding it. Okay.
Okay, ma'am.
Okay. Okay. So, yes, Ajit Kumar, you have any question?
यस मैम मैं पूछ रहा था मैम, ये एफिडेविट और ये वेरिफिकेशन में क्या डिफरेंस होती है?
सी एफिडेविट में आप ओथ ले रहे हो, और वेरिफिकेशन का मतलब है कि जो ऊपर चीजें मैंने लिखी है वो मैंने ही लिखी है. यू आर वेरीफाइंग ना कि मैं जो कुछ बता रहा हूँ ये वेरीफाई. हम क्यों उसमें कमिश्नर का नाम लिख रहे हैं या किसी ऑफिसर का नाम लिख रहे हैं कि ये वो पर्सन है जिसके सामने मैं ये सबमिट कर रहा हूँ, और ये जो चीजें मैंने इसमें लिखी है ये ट्रू ऑफ माई नॉलेज है. उसके लिए हम उसमें वेरिफिकेशन लिखते हैं. जैसे हमारी प्लेंट में भी आपने देखा कि उसमें वेरिफिकेशन पार्ट है. क्यों वेरिफिकेशन पार्ट है? ऑफ कोर्स वो बनाया तो प्लेन स्ट्रक्चर, आप बीइंग एडवोकेट, आपके क्लाइंट ने जो बोला वो आपने लिखा, ठीक है. बट क्लाइंट भी कह रहा है कि जो चीजें मैंने इस इंसान को बोली है उसने उस तरह से उसमें लिखी है, और मुझे पता है कि इसमें क्या लिखा है, मुझे नॉलेज है इस चीज का. ठीक है. तो इसके लिए हम उसमें वेरिफिकेशन लिखते हैं.
ओके मैम, थैंक यू.
Yes. Okay. So with this, I have first time I have completed the session 10 minutes before. Okay. From tomorrow I will be starting with the written statement and the another parts which have left. Okay. Then notices. So I'll try to complete it within the time limit which I have been given. Okay. So till then, have a very good night and thank you so much, everyone. I hope you understood.
Yeah,
Thank
good
you.
night, ma'am.
Yes.
Thank you.
Good night. Thank you, everyone.
Okay, ma'am. Thank you, ma'am.
Good night, ma'am.
Thank you.